Article 1, Section 9, Clause 7 of the Constitution states, "No money shall be drawn from the Treasury but in consequence of appropriations made by law." Seems pretty straightforward, doesn't it? So how could Congress establish a government agency funded not by appropriations from the Treasury, but by fees paid to another federal entity? This was a question brought to the Supreme Court in the case CFPB versus Community Financial Services Association of America. Sadly, it seems that the Supreme Court, once again, showed they have a hard time reading and understanding the English language. So we'll look at this next on the Constitution Study.
Neighbors and have a few good friends. Every day we're everyday Americans. Oh, every day we're everyday Americans.
Hello there, everyday Americans. Paul England here with the Constitution Study, where we read and study the Constitution. Teach your generation be free. I'm glad you could join me today. You know, we should be used to it by now. Attorneys have a job to do. That's to represent their client. And if it means twisting and twerking and manipulating the English language to get there, well, so be it. Sadly, those attorneys become judges, and it appears they're just as willing to twist and torture the English language to get the outcome they want as well. That seems to be the case here in CFPB versus CFSA. There's a mouthful. Now, if you want to find the links to all the quotes I make, there on the article on the website, constitutionstudy.com. But for now, let's take a look at this case with the Consumer Financial Protection Board and this odd funding method. One of the features of court opinions I often point out is how rarely they actually quote the Constitution. So I was initially pleased when the Supreme Court actually quoted the Constitution in the case CFPB versus CFSA. The Constitution gives Congress control over the public fisc. I simply mean fiscal powers, subject to the command that no money shall be drawn from the Treasury, but in consequence of appropriations made by law. Sadly, that initial feeling of pleasure quickly evaporated as I read the syllabus of the opinion. For most federal agencies, Congress provides funding through annual appropriations. For the Consumer Financial Protection Bureau, however, Congress provides a standing source of funding outside the ordinary annual appropriations process. Specifically, Congress authorized the Bureau to draw from the Federal Reserve System an amount that its director deems reasonably necessary to carry out the Bureau's duties, subject only to an inflation-adjusted cap. For over 220 years, Congress had funded federal agencies through appropriations from the Treasury. Then in 2011, Congress decides to fund a new agency in a different way. After this new agency promulgated rules that members of the CFSA objected to, the trade agency sued, making several claims of both statutory and constitutional violations. In the operative complaint, the association argued, among other things, that the Bureau takes federal government money without an Appropriations Act in violation of the Appropriations Clause. Now, for this reason, the court looked to the Appropriations Clause, but it seems they only focused on one word: appropriations. Since the court seems so focused on the word appropriations, let's start there as well. According to Webster's 1828 dictionary, an appropriation is the act of sequestering or assigning to a particular use or person in exclusion of all others, application to a special use or purpose. An appropriation is merely the setting aside of something to a particular purpose. In the case of the Appropriations Clause, it's the setting aside of money. Again, from Article 1, Section 9, Clause 7, no money shall be drawn from the Treasury but in consequence of appropriations made by law. So the U.S. Treasury cannot send any money until Congress has set it aside for a specific purpose by passing a law. Again, seems straightforward enough, doesn't it? Now, this case was first heard at the district court, which found the court explained that the Appropriations Clause means simply that no money can be paid out of the Treasury unless it has been appropriated by an act of Congress. And because a statute authorizes the disbursement from the Federal Reserve System combined earnings to the Bureau up to a certain cap, the district court concluded there is no Appropriations Clause issue. According to the district court, Congress passed a law to authorize the Federal Reserve System to spend money, so there is no Appropriations Clause violation. However, the case didn't end there. On appeal, the associations renewed their argument that the Bureau's funding mechanism usurps Congress's role in the appropriation of federal funds by allowing it to take federal money without an Appropriations Act. The Court of Appeals agreed with the argument and reversed. Drawing on the Constitution's text and history, the court concluded that the Appropriations Clause does more than reinforce Congress's power over fiscal matters. It affirmatively obligates Congress to use that authority to maintain the boundaries between the branches and preserve individual liberty from the encroachment of the executive power. By giving the Bureau a self-actualizing perpetual funding mechanism, the court reasoned Congress, in effect, abandoned this obligation. It was not enough that Congress enacted the law authorizing the Bureau's funding because a law alone does not suffice. An appropriation is required. The court thus held that Bureau's funding mechanism violates the Appropriations Clause. The CFSA argued, and the Circuit Court agreed, that it's not enough for Congress to pass a law, but they must pass an actual Appropriations Act for the purpose. The Supreme Court disagreed. Held, Congress' statutory authority allowing the Bureau to draw money from the earnings of the Federal Reserve System to carry out the Bureau's duty satisfies the Appropriation Clause. How did the court come to this conclusion? Under the Appropriations Clause, an appropriation is a law that authorizes expenditures from a specific source of public money for designated purposes. Okay, so far the court is correct. An appropriation in this context is a law that authorizes expenditures from a specific source for a designated purpose. Sadly, though, the court's decision quickly goes off the rails. The Bureau's funding is drawn from the Treasury and is therefore subject to the requirements of the Appropriations Clause. Except the CFPB's funding isn't drawn from the Treasury. It's drawn from the Federal Reserve, a semi-executive agency. The court recognizes that under the Appropriations Clause, an appropriation is a law authorizing the expenditures from a specific source, but that source must be the U.S. Treasury. So does the CFPB funding even raise an appropriations question? Since the Dodd-Frank bill that created the CFPB appears to have been attempting to find a funding source that was not up for regular congressional approval, we have to wonder why. I believe Justice Alito gives us a clue in his dissent. Since the earliest days of our republic, Congress's power over the purse has been its most complete and effectual weapon to ensure that the other branches do not exceed or abuse their authority. The Appropriations Clause protects this power by providing that no money shall be drawn from the Treasury, but in consequence of appropriations made by law. This provision has a rich history extending back centuries before the founding of our country. Its aim is to ensure that the people's elected representatives monitor and control the expenditure of public funds and the projects they finance, and it imposes on Congress an important duty that it cannot sign away. Any other course would give the executive a most dangerous discretion. There's more to the Appropriations Clause than just the appropriation of money. No money shall be drawn from the Treasury, but in consequence of appropriations made by law. And a regular statement and account of receipts and expenditures of all public money shall be published from time to time. While the Treasury is required to regularly provide a statement and an account of all receipts and expenditures, the Federal Reserve is not. From the Federal Reserve website, the Board of Governors and the Federal Reserve banks annually prepare and release audited financial statements reflecting balances as of December 31st and income and expense for the year that ended. The Federal Reserve Bank's financial statements also include the accounts and results of operations of two limited liability corporations that have been consolidated with the Federal Reserve Bank of New York and one LLC that has been consolidated with the Federal Reserve Bank of Boston. It appears that Dodd-Frank attempted to bypass not only the routine appropriations process to have a regular source of funding, but the reporting requirement of the U.S. Treasury as well. This appears to be an attempt to remove CFPB from congressional oversight, which brings up another question. Was Congress attempting to establish an executive agency that was outside the power of the purse the Constitution delegated to Congress? The Constitution is very specific. Congress can only collect taxes of various forms for three very specific purposes, and consumer protection is not one of them. From Article 1, Section 8, Clause 1, we read, "The Congress shall have the power to lay and collect taxes, duties, imposts, and excises, to pay the debts and provide for the common defense and general welfare of the United States." Congress is not authorized to collect fees to fund an agency, or anything else for that matter. Furthermore, by funneling these ill-gotten fees to the Federal Reserve, Congress is attempting to hide this money from the Appropriations Clause reporting requirements, thereby hiding it from the American people. In short, it appears Congress has been cooking the books by hiding a portion of its taxing and spending through the Federal Reserve. Why would Congress create an agency that was outside its most powerful oversight tool? Was it the intent of Congress to create an unaccountable agency? Or was it the intent of a couple of congressmen and the rest of Congress simply went along with it? In any case, what we have here is not only a violation of the appropriations part of the Appropriations Clause, but of its reporting requirements. More importantly, we have a violation of the 10th Amendment, since Congress has empowered a federal agency outside of the United States Treasury to spend money, not a power delegated to Congress. Now, leave it to lawyers and judges to twist a simple sentence to make it say something completely different. The Appropriations Clause is pretty clear that money cannot be spent out of the Treasury without appropriations. The court, though, has somehow deemed a semi-government agency, the Federal Reserve, is actually the United States Treasury. The Congress has not delegated the power by the Constitution to allow entities other than the Treasury to spend public money, especially for the purpose of hiding it from the American people. As Justice Alito stated in his dissent, the court upholds a novel statutory scheme under which the powerful Consumer Financial Protection Bureau may bankroll its own agenda without any congressional control or oversight. Once again, the court turns its head away from the law and justice for a political agenda. Of the 9 justices on the court, only 2, Alito and Gorsuch, saw some of the problems in this funding mechanism. What's even worse, now that the court has placed a false imprimatur of legitimacy to the CFPB's funding mechanism, what is to stop Congress from doing this for other agencies? Finally, the associations contend that if the Bureau's funding mechanism is consistent with the Appropriations Clause, then Congress could do the same for any or every civilian agency, allowing the executive to operate free of any meaningful fiscal check. Imagine a country where agencies like the EPA, DOJ, or Social Security no longer need congressional approval to spend money, and none of the details are actually reported. All these agencies would need to do is tell the Federal Reserve how much they want, as long as they stay within limits Congress has set. I guess that's one way for Congress to get out of its responsibility to pass a budget. All they'd have to do is pass a single one-time bill saying how much any agency could draw from the Federal Reserve, and how much that pot would grow every year. What do you think our national debt would look like then? So once again, the Supreme Court becomes an accessory after the fact to the criminal activities of Congress. The whole CFPB debacle is unconstitutional. It's a violation. There's no power to regulate financial transactions delegated to the United States. The whole thing is a scheme. Well, actually, the whole thing is criminal. It's the funding mechanism that is a scheme, an attempt to get an agency out from under not only congressional oversight, but the oversight of the people. And the court went along with it. Well, at least 7 of the 9 justices did. And for all those who look to a Thomas or a Kavanaugh as, staunchly conservative, protect us and protect the Constitution, they failed here. This is why you need to read and study the Constitution for yourself, so you know better. Now, how we deal with the CFPB is something I'll have to deal with somewhere else. But the first step is recognizing just the criminal activity that's involved in this bureau. I'm not sure if this is money laundering or embezzlement or just plain extortion. But what you have is a bureau that is outside of congressional control. There are no limits on what it can do. Actually, I take that back. The only limit is Congress gave them an inflation-adjusted cap, and as long as they stay under that cap, they can do whatever they want. What if they go too far? So what? Who's going to harm them? Well, you take them to court and they lose. So what? Who's going to dock their pay? Who's going to restrict their funding? Congress gave all of that up. Illegally, by the way. I know this is kind of an out-of-the-way sideball case that most of you probably weren't thinking of. But as you see, even there are serious constitutional issues we need to consider. That's why I hope you check out the website, constitutionstudy.com. Maybe check out the radio program at americaoutloud.news. These are both sources of information. I do articles and videos on the primarily on the website, constitutionstudy.com. And then I've got my radio program on americaoutloud.news. You can find all sorts of information. You can share all sorts of information. And hey, if you can support the work that we're doing here by buying a book or just donating, hey, that'd be wonderful too. The point is, I'm here going through the work, getting this data, doing the research to help inform you about the constitutional issues of what's going on in this world. I hope that's worth something to you so you can help support the work that I'm doing. Maybe just share the work that I'm doing so that other people can find the Constitution Study as well. Hopefully you'll bring someone along and join us here for the next time on the Constitution Study.
Love your neighbors and have a few good friends.